16. Both are transfer pricing matters.
Lordship, appearing for the respondent in 15. Should maybe taken next week, Your Lord.
Transfer pricing remanded another
But their
on limitation.
issue is on limitation, my lord.
on limitation
Limitation. But
after
maybe
2 weeks.
2 weeks.
2 weeks at the request of Sissy.
Lordship, 19 is transfer pricing.
19.
19. It may be adjourned for 4 weeks.
For
Lordship, serial number 17, my lordship. The previous counsel is retiring from the case. So respondent have informed us to appear for this case.
you are appearing.
Yes, I'm for the respondent.
What's your name?
M. Mahalakshmi. My senior will be appearing.
No, no. Well, Kempraju is
17.
serial number 17.
17. Mr.
17.
Kemparaju, the previous advocate,
17.
17.
No, no. Sri
My
Kemparaju.
lordship, I request 3 weeks time, my lordship, because we have not received the case papers yet. And we have to file new colors.
Sri Kemparaju BG on request is permitted to retire. And in his stead, Srimati so and so appears. First, Kemparaju to hand over the papers to new counsel immediately. Okay.
Lordship, serial number 22. Your Lordship. Maybe listed after 2 weeks. Not rule was issued on the last date of hearing.
Yarappa.
Serial number 22. Your Lordship.
22.
Rule was issued on the last date of hearing. Lordship, the pleadings are not yet complete.
Okay. Since rule is issued in this matter, call the same in usual course.
Great. Grateful.
Lords, may I be permitted to take notice in this matter?
Srimati so and accepts notice for the assist. Admit agilla.
Your Lordship, I will search the copy, let it come in
But
the
it-
due course.
Next.
My lord, for the appellants, my lord.
Ah.
My lord, in the previous date of hearing, the Honorable Court had granted us 2 weeks' time to file additional affidavit. Just to emphasize on one aspect as to the receipt of certified copy by the client of the order copy. My lord, but unfortunately, the director whom we were in touch with has met with an heart attack, and it was hard for us to seek instructions from him. So I just request some more time, my lord. We will.
Call after 2 weeks on the health ground of official at whose from whom information is sought for preparing the additional affidavit.
Much obliged.
90 days delay.
My lord, that was the point of contention. We received it
ಅಲ್ಲೇ
on-
ಇವ್ರು ಯಾರಿದ್ದಾರೆ ಸರ್ವಿಸ್ ಇದು ಆಗಿಲ್ಲ ಇನ್ನು ನೋಟಿಸ್ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. The additional affidavit may be filed in due course. Okay.
Much obliged.
Commissioner. ಯಾರು ಬರ್ತಾರೆ? PG ಅಲ್ಲ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಾರೆ. ತಿವಾರಿ ನೋಡಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ತಾನೇ?
ಹೌದು.
ಇಲ್ಲ ಶ್ರೀ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ Tiwari on request accepts notice for the respondent. 90 days delay there.
That can be condoned.
My lord, the point of contention is we receive. Okay.
Application allowed other standard format. Delay is short and one sentence. Okay. Yes.
Much obliged.
Better affidavit.
Mellows 3 and 4, my lords, both are from the same assessee. Issue of transfer pricing, Mellows on comparables. The delay of 435 days, my lords. Mellows that may be condoned, my lords, subject to some book. I'll give some books, my lords.
Now books good.
Mellows, I'm carrying a book, my lords, of Vikram Sampath. It's
Yeah.
due on the library, my lords. It speaks about, my lords, all
A
the
historian.
historians, my lords.
Okay. It's from Indian history. Vikram Sampath. He's a great historian. No, ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. Delay condoned. ಅದೇನೋ ಅದು ಕಂಡೀಷನ್ ಹಾಕೋದಿದೆ. Just ಹಂಗೆ ಬರೀಬೇಕು. Is given to counsel appearing for the assessing. You have to read it.
Yes, my lords.
Next time you'll ask some questions about that. Yes.
Both matters, my lords, 3 and
Latest
4.
book is on Shiva.
Sure, my lords, yes, my lords.
Yes. ಇಲ್ಲ ಇಲ್ಲಿ ಇವ್ರಿಗೆ ಕೊಟ್ಟು ಇನ್ ಬುಕ್ಸ್ ಯಾರಿಗೆ ಕೊಟ್ರಿ?
4 also, my lords, same, my lords.
ಇನ್ನೊಂದು ಪುಸ್ತಕ ಕೊಟ್ಟು
Yes, my lords.
ಯಾವ್ದು ಕೊಟ್ರಿ?
My lords, there's a new book, my lords, of Arun Shauri, my lords, on new icon and new facts.
ನೀವು
of-
ನೀವು
He describes, my lords. what-
ಅರುಣ್ ಶೌರಿದು ಕೋರ್ಟ್ಸ್ ಅಂಡ್ ದೇರ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್
Yes,
ಕೊಟ್ಟು ಬಿಡಿ. ಓಕೆ
Yes, my lords.
ಟೇಕ್
I'll take it.
ನೋಡಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್
I'll file my.
delay condoned signs. Okay. Okay.
Lordship, I pray for some time, your lordship. Yesterday evening only they have served the
That's not
copies, your
correct.
lordship. Some
want
time.
time?
Yes, your lordship.
Sorry.
4 weeks may be granted, your lordship.
2 weeks.
Much obliged.
Next.
Lordship, I pray for 2 weeks time to file additional affidavit, my lord.
Additional affidavit.
Yes, my lord.
ಯಾರು?
Your lordship,
ಪ್ರೇರಣ. ಎಲ್ಲಿ
Oh.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲಿ?
they are online.
Yes, please.
ಪ್ರೇರಣ
I appear
ಮೇಡಮ್,
on behalf-
you
I
take
appear on
some
behalf
two
of the
books,
respondent.
will condone
My
delay.
lords, that is all right, but my lords, our only grievance over here is that in the affidavit accompanying their application for condonation of delay, the date of the impugned order has wrongly been mentioned as 31st.
Therefore, I will.
When you come here with delay,
That may
we will
be
extend the
corrected.
same facility to you. So after all delay, it is not that matter is, all old matters are languishing in the court cupboards. It is not that
I
if this
understand.
was filed in time, everything would have happened.
I understand, my lords. It's just that they may be directed to file a better
I will file it,
affidavit
my lord.
explaining the
Okay.
delay.
Requirement of filing better affidavit is dispensed with. First, appeal is filed after brooking a delay of so many days, and an application supported by an affidavit accompanies the same. First off, a perusal of the application shows that there is a plausible explanation for the delay brooked. And therefore application needs to be favored. First, contraposition would do injustice to the revenue. First, after all, condonation of delay would not add any merits to the appeal to the disadvantage of the other side. First, we also note that much older matters than this are languishing in the court cupboard. First, in the above circumstances, application is favored unconditionally and delay is condoned. Okay.
Much obliged.
My lords, just one more request. Shri Aditya Vikram Bhatt's name is appearing. It is requested that that may be deleted and Mr. Anand Thomas's name be added.
ಏನಂತೆ? Name of Aditya Vikram Bhatt to be deleted and in his stead
Anand
delete
Thomas.
may be deleted, since he is permitted to retire. Okay. Next. ಅಲ್ಲಿ ಬೇರೆ ಡೇಸ್ ಇದೆ 300 ಎಲ್ಲ 300 ಡೇಸ್ ಇದೆ ಇಲ್ಲ ಬೇರೆ ಡೇಸ್ ಇದೆ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್. ಎಸ್
Your lordship, short delay, my lord.
madam, application allowed condonation 17 days. Yes,
Your lordship, transfer pricing issues are involved, my question 1 to 4 may kindly be admitted.
admitted on question number substantial questions of law, following substantial questions of law 1 to 4 are
Yes, my lord.
to 4. ಕೆಳಗಡೆ we note that so and so similar questions are being debated on the floor of this court in an ongoing matter. Yes. Next.
I pray for the,
Yes.
I pray for the petitioner, my lord.
My lord, I have filed an application for vacating stay.
Yes.
Lord,
The
they have
fact
filed
of-
the counter affidavit, my lord. I am ready to argue the matter, my lord. My lordship may fix a date or my lord.
No,
you
my
will
lord, it is not.
start-
No,
if you
may,
want me to
may
start, I
make my
will start.
submission, may make my submission, my lord. The petitioner before this honorable court is a bank. Bank had financed me, I am a gold merchant. In 2007, there was a burglary in my shop.
Yes.
7 kg 63 grams of gold was burgled from my shop. Then the value was 63 lakhs rupees. Now the value is 9 crores. There is a decree now for 1 crore 63 lakhs with interest. Let them first deposit that money. I am in
Lord, my
debt now.
liability has to
Since
be-
that day, from 2007 till today, I am sinking day after day. My health has gone. I am all virtually on bed now. Because I could not recover from that 7 kg gold that has been stolen from my shop. There was a
By whom?
burglary. People from Maharashtra came. He was almost closing the shop. At the point of the gun, even the police could not do anything.
Unknown
And
persons, my lord.
it was investigated at all level. They have filed a C report saying that these people from Maharashtra, we are not able to trace. Thereafter, insurance company was approached. Insurance company said, we had insured for this shop. Burglary has taken place in that shop. We are not liable to pay. The bank has admitted its mistake, saying that by mistake we have given this number, and they have admitted their mistake. Therefore, the Consumer Commission held that the bank is liable to pay the money to me. And they approached the National Commission. National Commission confirmed that judgment by holding that your own letter is against you, so pay the money. Instead of filing an appeal before the apex court, they have come before this honorable court. And on 26/9/2024, they filed the writ petition here. On 4/11/2024, when the matter was before the State Commission in the execution case, when the court was ready to issue the delivery attachment warrant against the head office of the Bank of Baroda, they said that we will comply the order. They did not disclose that this matter is pending before the court.
Where is that comply the order and ಹೇಳಿದ್ದು?
Illi page number
Page number 28 in there.
Page number 28.
Not 28,
In the
I'm sorry.
statement of objection, order sheet
I'm
I
sorry.
have produced.
Page number 15.
15.
15. It was the first appearance on 4/11/2024. It reads, my lord, Mr.
second-
Nagaraj Damodar, advocate, files wakalat. JDR directed to comply with the order, or else commission will take coercive steps by next date of hearing, my lord.
Your lordship may
But
kindly
now
see-
this has been, my lord, stated to be professional misconduct in the my lord, in the counter affidavit.
My lord,
I'm sorry, my lord, this is,
they
I take exception to this.
They have to disclose before the court that a writ petition is pending before the court. On 6/7/22, the order of,
One date thought in final disposal.
Disbursement. Lord,
my
Yes.
lord, my submission is,
Today, not possible.
please, my lord.
Fix a date in first week of March. We will
My-
hear and
my
decide
lord,
of the
it-
matter.
it-
Within 15 days, nothing is going to happen. Choose a date from calendar. Otherwise, you argue, we will hear whatever order we want to pass, we will pass.
25th of February, my lord.
ಆಗಲ್ಲ. ಬೇರೆ matters ಇದೆ. ಅದು ongoing matters ಇದೆ. Otherwise, you would have taken. We understand the difficulty of your client also, because you said
Please, my
all
lord.
these years and.
both shops are his, my lord.
Huh?
Both are his
My-
shops.
My lord,
Lord, I am a banker. Lord, I have given him loan. So I will take insurance to the extent of my loan, my lord. Why I should, my lord, insure all his shops?
No, since you insured a wrong number,
No, no, even that is his shop only. And in his loan documents, he does not mention any shop number at all.
page-
I will show it, my lord, when my matter is argued.
page 83, my lord, their own letter.
That's correct.
We
sir.
regret to inform you that in the insurance proposal by clerical mistake and by oversight, we have omitted to include shop number so and so and so. It is the mistake of the bank.
they admitted it.
They have admitted, page 83. On that basis, the State Commission has held against them. They have absolved the insurance company. Then the National Commission has absolved insurance company and has
ಆ ನಂಬರ್ ಸರಿ ಬರ್ದಿದ್ರೆ ಇನ್ಶೂರೆನ್ಸ್ ಸಿಕ್ಬಿಡ್ತಿತ್ತು.
ನನಗೆ ಸಿಕ್ತಿತ್ತು.
And he would have had to pay double premium
No,
that he wanted to avoid.
my lord.
Lord, insurance is for one premises.
But your bank admitted the
No,
mistake.
no, Lord, that is post facto, my lord. Post facto, we wanted to help him. Lord, that letter does not contain anybody's signature, seal, nothing is there.
There is signature,
Have you
there is a
disputed?
letter.
Lord, we have
The
unfortunately.
lordship
not-
may page number
No, no,
81.
but
your
that
lord-
will not, Lord,
This
Page
is
number
question
81,
question
page
is of
number 81,
deficiency
there
of
is
service.
signature, my lord.
Not
Now-
my service is not insurance. I take insurance for my own,
Goods.
to to Milord safeguard my risk. I have given him 66 lakhs loan. I take insurance for 66 lakhs. Why I should insurance all his shops, Milord?
It is insurance is against the loan,
Against loan.
not the goods.
No, Milord. The goods are hypothecated. To that extent, I will take loan, Milord. Now he is saying you should have taken loan for both my shops. Why I should take loan?
Shop is.
I am a
at the-
banker.
Shop.
My service is not, Milord, insurance.
Hypothecation. Custody of the goods will remain
With the,
with the hypothecator.
yes, Milord.
Hypothecator, that's the law.
That's the,
And whose duty it is?
there is nothing, Milord. There is, Milord,
Halsbury discusses this.
Milord, in the insurance, Milord, in the loan documents, there is no duty on me to take insurance. I take
No, not
insurance to
insurance.
cover my own risk.
Who is that? Whose duty it is to protect the hypothecated goods? Halsbury says, to my vague memory, the hypothecator is the duty of the hypothecator to safeguard the hypothecated goods.
Goods.
Just look into that
Yes,
also.
Please, man.
Therefore, look into that and come.
Correct.
And then your insurance policy produce ಮಾಡಿರೋ no?
ಹೌದು ಎಲ್ಲ produce
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. ಎಲ್ಲ ಇದೆ.
Date
All
fix
documents are
ಮಾಡ್ಕೊಳ್ಳಿ.
there.
First week of
A date may be given at.
ಹೇಳಿ ಚೂಸ್ ಮಾಡಿ ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು
ಅಲ್ಲ, March 3rd, my lord.
ಥರ್ಡ್
3rd of March. ನೋಡಿ,
Third.
ಥರ್ಡ್ ಆಫ್ ಮಾರ್ಚ್
3rd of March. Oblige.
entry more to continue. Yes,
Appearing for the petitioner, please, my lords.
yes. ಏನಿದು
My lords.
ಮೇಡಮ್ ಗೀತಾ?
This petition is in challenge, my lords, to the impugned order passed by the state, Karnataka State Consumer Dispute Redressal
State forum.
Commission. Yes, my lords. The KSC DRC, my lords. The impugned order is at Annexure A, please, my lords, which is an order passed in execution proceedings EA 47 of 2017 on an application that was filed by the petitioner for an application that is at Annexure B, my lords,
The
which has-
petitions are here.
my lords.
You had filed the application.
No, my lords.
Huh.
Everything is before the KSC DRC only, my lords. If
Okay.
I may just take, my lords, to the brief facts of this case, my lords, it will be a little clear. May I take, my lords, to page number 66, please, my lords?
66.
Yes, my lords. My lords, this is the case where one Dr. V.S. Rajama files an application, my lords. I've even given a type copy also, my lords. Dr. V.S. Rajama, the type copy, my lords, will find in page number 67, please, my lords. Here, my lords, Dr. V.S. Rajama, she submits an application for admission as a nominal member with the Vayalikaval House Building Cooperative Society, my lords. She has been allotted an account number of 8498. Kindly note the date, please, my lords. It is 1/7/1983.
1783.
Yes, my lords. If my lords may please come to page number 66, my lords, which is the original application, and kindly note the signature of V. Rajama, please, my lords. This is one of our major grounds, please, my lords, that the complaint has been filed beyond limitation and it's on forged documents, my lords. Then what happens, my lords? Page
When,
number. My lords,
When those forged signatures were made on which date, according to you?
I'll take this quote through all the documents, please, my lords.
We are asking a date, a year.
Uh, Just a minute, please, my lords.
Because
Page number
signatures
52.
vary every 7 years. This
Here
is
that-
what the handwriting experts say. Therefore, we asked
Yes, my
on
lords.
which date these were executed.
My lords, page number 52, the entire name itself is changed, my lords. Page number 52, please, my lords, which is Annexure B7.
Date is
My lords, the date is 2010-1998.
20,
2010-1998. It is 28 or 20, even that's not very clear, my lords, but it's the 10th month of 1998. This is almost after 15 years of making all the payments. Kindly note the date, the name, my lords, the signature put below is C.S. Rajamma,
V.S. Rajamma.
C.S. Rajamma. And kindly note the signature, my lords, a gross difference, my lords.
How
Here.
the different, this forged or not, any efforts were made at the hands of the expert?
My lords, unfortunately, this order was passed in 2014 in the complaints CC 312 of 2014. Execution was in 2017, my lords. And the petitioner who is the OP there and the JDR in this EM, my lords, was not even aware until the NBW was issued to him in 2022. I came on record only in 2023, my lords. And from then on, I've been trying to bring it to the notice of the commission that this complaint is hopelessly barred by limitation, my lords, as per the judicial reasoning of the Honorable Apex Court in this important judgment, please, my lords.
ಏನಂತ? Sorry. Proposition ಹೇಳ್ಬೇಕು, ಆಮೇಲೆ judgment ಕೊಡ್ಬೇಕು.
I'm sorry, my lords. My lords, under section 24A of the old act, my lords, 1986 CP Act,
What is the period of limitation?
only 2 years, my lords,
2 years for?
for filing the complaint from the date the action, the cause of action accrued.
Did you take up that contention?
My lords, a good number of times, but
Where is that first time you took that contention?
my lords, even in the application which I filed recently, my lords,
Not recently, earliest point of time.
my lords, because the documents would have been very heavy and huge, my lords, I have not put those applications.
One document.
There are 3 applications I put, which have all been dismissed, my lords, even under section 47 also. But here the latest application, please, my lords.
That
Which
you
is at
filed
annexure
it,
B.
you filed it in execution proceeding.
Yes, my lords. Because we came
up-
on, board.
Apex Court said in 1964, a decree passed in a time-barred cause is a decree not without jurisdiction.
yes, my lords.
It goes against you.
My lords, I'm the JDR, my lords, I'm the DHR.
Only JDR can take this contention.
My lords,
Freeholder cannot.
my lords. That,
I've seen that judgment.
yes, my lords, that's one of the judgments I have found and I've given to this honorable court, that if the complaint is taken by the commission, which is time barred, then the order by itself deserves to be set aside.
It just to be set aside is one thing.
And hence, my lords, it cannot,
Listen to us first. Why are you in so much haste? Are you going to attend any other court here?
no, my lords.
You complete and
That's-
come back. We'll hear
No, my
you.
lords. That's in 81, my lords.
81. Which court?
Court hall number 14, serial number
You
82.
complete that. and
No, no,
come.
my
We'll
lords.
leisurely
No, no, my
hear.
lords. It has to reach its way much later, my lords.
Ah. The Apex Court said a decree passed in a time-barred suit is a valid decree. It's a constitution bench judgment. If I am right, it is 1964. Because limitation is a mixed question of law and facts. Therefore, Supreme Court said, Honorable Supreme Court said, it is not a decree without jurisdiction. This is number one. Number two, you are saying another judgment of Apex Court which says in a time-barred complaint, if order is passed by the forum, it is without jurisdiction.
Yes, my lords.
It is without jurisdiction is one thing. It is liable to be set aside is another.
Both are here in this, my lords.
Both are here.
Yes, my lords.
Which is
Page number 5, please, my lords.
Page number
Page number 5, my lords.
5.
This is the judicial reasoning of the Honorable Apex Court and SBI versus BS Agriculture, my lords, in page number 5,
Paragraph.
paragraph 12, my lords. The 5th line, please, my lords. In other words, it's the duty of the consumer forum to take notice of section 24A and give effect to it. If the complaint is barred by time and yet the consumer forum decides the complaint on merits, the forum would be committing an illegality and therefore the aggrieved party would be entitled to have such an order set aside.
Correct. Illegality. It is not without jurisdiction.
My lords, even if I have to change that word, it's not jurisdiction. It is illegal and it has to be set aside.
That you have challenged here now.
Yes, my lords.
Where is that?
That's one of the grounds I've taken, my lords. I have said this also in my application, my lords.
You have challenged the order in execution.
Yes, my lords.
But original order you have not challenged.
My lords, ನಮ್ ಗಮನಕ್ಕೆ ಇರ್ಲಿಲ್ಲ, my lords. If I can take,
It's
my
after
lords,
ಗಮನಕ್ಕೆ ಬಂದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
my lords, 23 onwards after I have come on record, my lords, I've given umpty number of applications, including this application, where I've
How
mentioned
can,
that it is beyond
why
limitation.
can't you understand small things?
Yes.
The executing court cannot go behind the decree. Same principle applies to this also. Unless that order is set aside on the ground of illegality, this order would remain.
Yes, my lords.
Therefore, you have to challenge that order.
My lords,
After
that's-
coming to know of that, there may be delay. Order is illegal. Does not make it order non-est. Write down. Take down, read and come. AR 1992, Supreme Court, 111, paragraphs 5, 6, 7. ಇದೇ ಕಂಟೆನ್ಷನ್ ಟ್ರೀಟ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಇದು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ಇಲ್ಲಪ್ಪ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಯಾಕೆ ಅಂದ್ರೆ ವೈ? ಬಿಕಾಸ್ ದಿಸ್ ಈಸ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್. ಇನ್ that you have resisted the execution on the ground that that order is illegal. That illegality executing court cannot decide.
Yes, my lords, that's a predicament, yes.
Therefore, you should have challenged that order. You could have explained the delay, saying that never we were aware of all these things. Once you are not aware of that, then it's a ground for condonation of delay.
No, that's the reason we came before this honorable court, my lords.
Where you have challenged that original order.
Unfortunately, that's what my thought. I thought, my lords,
Unfortunately, we
if
can't do anything.
we could challenge that before this honorable court, my lords.
Madi,
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು ಈಗ.
same order,
Yes, my
original
lords.
order.
ಯಾಕಂದ್ರೆ yes, my lords.
is it?
ಹೌದು, my lords. ಅದನ್ನೇ ಹೇಳಕ್ ಬರ್ತಿದ್ದೆ ನಾನು.
But 21 December 2024 ಇದೆ.
My lords, that was the order passed in execution on my application, wherein I have told and brought it to the notes of the commission that this is barred by limitation, hence it has to be set aside. And my lords, there are 3 people who put the signatures. ಯಾರು ಒಬ್ಬರನ್ನ ನೀವು ಕರ್ಸಿ ಅಂತ ಹೇಳಿ.
ಒಂದೊಂದೇ ಪಾಯಿಂಟ್ ಮಾಡು.
Yes, my lords.
Confuse us much. Which is the original order that is put into execution?
My lords, Annexure G, please, my lords. Page
G.
number 76.
76.
Yes, my lords.
You are right. You are
May I-
right.
Grateful, my lords.
Yeah, I was under impression. I'm wrong. I was under impression that you were challenging collateral proceedings. You have rightly challenged this order.
My lords, here in,
What is the explanation for delay?
my lords, here.
30 years.
My lords, absolutely no application filed and no continuation of delay, no mention at all about the limitation barred or anything, my lords. On the contrary, my lords, para 2, on service of notice through the paper publication, OP remained absent. So, my lords, I put a application to the commission and page number 80, my lords, they give me a himbaraha. ತಾವು ದೃಢೀಕೃತ ಪ್ರತಿ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ 21-2025 ಅರ್ಜಿಯಲ್ಲಿ CC 312 of 14 ಪ್ರಕರಣದಲ್ಲಿ ದಿನಾಂಕ 33-2016
Not available at all.
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇಲ್ಲ, my lords. Paper publication illa, another big fraud cleared the commission, my lords. So based on that faith, the commission passes this order, my lords. And if I can take my lords to the actual order sheet, my lords. Order has-
No, you have made out a case for admission in the interim order. Very good.
Grateful, my lords.
Issue emergent notice, interim order as prayed for till next date of hearing. You are right.
Entry order, please, my lords.
Yes.
Grateful, my lords.
Yes.
I appear for. My lords,
ಹಾ,
Central Access Appeal.
ಅಲ್ಲಿ ದೇಶಪಾಂಡೆ ಹೆಸರು ಇದು ಮಾಡ್ಬೇಕಾನು?
House Deshpande ಮತ್ತು ಪ್ರೀತಾ ಮಹಾದೇವನ್ ಅಂತ
ಇಬ್ಬರನ್ನು
ಇಬ್ಬರಿದ್ದಾರೆ.
ಹೆಸರು.
File has been transferred.
Niralgi or dearly.
Please.
Yes, brother.
My lord, the
You are
issue-
for respondent.
Yes, Lord.
Assessee.
Yes, Lord.
notice ಆಗಿಲ್ಲ ಇನ್ನು
Agila.
ಆಗಿಲ್ಲ.
ಏನ್ questions?
Questions, my lord,
Then substantial question of law ಮೇಲೆ.
ಹೌದು ಹೌದು.
Okay. Where is the substantial
My
question?
lord, it is on page number 12, my lords. But I would submit substantial question flow is not very happily worded.
ಇದು question of law ಆಗುದಿಲ್ಲ.
Question of
Let alone
fact.
substantial question. Question of fact. Mixed question of law and facts. That is equated with 100 ಈಗ.
That's CPC.
ಹಾ,
That's,
ಹಂಗಾಗಿ reframe ಮಾಡಿ.
I'll reframe it. I'll reframe it.
Learned panel counsel appearing for the appellant having argued the matter for some time seeks leave of the court to reframe the substantial question of law. First off, leave is accorded. Call after 2 weeks.
Adjourned.
Yes, sir.
May I please, my lord?
Ah.
I am appearing for the appellant. This is an appeal under section 35G of the Central Excise Act
Yes.
against the order of Sestat. My lord, the questions of law are at page 9, bottom onwards.
Questions of law or substantial questions of law?
Substantial questions of law are at
Page?
page 9, bottom in the last line. So I'll just explain what the issue is, my lord.
That was not stated in the notice at all.
I'll just explain what the issue is.
Yes.
The appellant, my lord, is an exporter of software. For it has contracts with its clients abroad for developing and exporting software. Now, as your lordships know, the entire software for a software to be developed and integrated with the client system who are all based abroad. Some of the services are provided from India and some have to be necessarily provided at the place of the my client who are all abroad in the foreign countries. So I have other contractors, subcontractors in those countries who are either my subsidiaries or third parties. I have a subcontracting agreement with them. Now, under the Service Tax Act, my lord, export of service is exempt, and any input service that I avail, I am entitled for SENVAT credit, and I am entitled for refund of that. So I made an application for refund. All along, my applications for refund were allowed, and this appeal pertains to the period June 2008 to October 2008 to June 2009. Except for this period, the prior period and the subsequent period, my applications were allowed, treating my service as an export of service and giving me refund of the SENVAT credit, which is basically the services provided by the subcontractors abroad to me, which is liable for reverse charge under Section 66A of the Finance Act, which I have paid. I am entitled for refund, and those refunds were granted. Only for this interregnum period, the refund was rejected initially by the authority on the ground that what you have done is not an export of service. The service is actually provided by your subcontractor abroad. That was the ground on which the order was passed. Order in original was passed. I filed first appeal, that was held against me, the second appeal. Now, what the tribunal says is the service is provided by the subcontractor. You had no liability under Section 66A to pay reverse charge at all. What you have paid is wrongly paid. Therefore, you are not entitled for refund. So they changed the entire basis of the show cause notice. Now, the point is this: whether I claim it as a refund under the rules as refund of the SENVAT credit, or even assuming the Sestat is correct, that it is, you are not even liable to pay that reverse charge tax, and you have paid it without authority of law, even then I am entitled for refund.
Yes.
So therefore, my lord, the tribunal was wrong in saying that I am not entitled for refund. And they could not have taken a ground to reject my appeal, which was not taken by the revenue in the earlier, in the show cause
Proceedings.
notice, in the earlier proceedings.
But the subject appeal is admitted on the following substantial questions of law. First up, emergent notice and interim order as prayed for. Heard senior advocate Mr. Surya Narayana for the SAC. First.
I am permitted to take a notice for the revenue matters.
Shri Niralgi, the senior panel counsel, is requested to accept notice for the revenue. Do you have a pen drive of your questions so that we need not go on typing?
I will provide it.
Provide that. Sure. It becomes easy for them. We have hands are, we don't have many hands here. ಅದು ಒಂದು ಎರಡು ಇದ್ರೆ ನಾವು ಮಾಡಿಬಿಡ್ತಿದ್ವಿ.
Grateful, not an issue. I'll provide it.
A slew of questions have been framed.
Yes.
They may arise also. We don't know. Yes.
Grateful.
Grateful.
This is the appeal filed by the revenue bill. The tribunal has set aside the order passed by the assessing authority, which on the ground that the basis for passing that order is on 1/263 order, revisional order passed by the commissioner. That revisional order was set aside by this honorable court in an ITA case. Therefore, the foundation does not survive. Your lordship,
On the tribunal ಹೇಳಿಲ್ಲ ನೀವು.
ಹೇಳಿದ್ವಿ, because the 263 order which has been set aside by this honorable court, we have taken it to Supreme Court and SLP is pending. It will depend upon the outcome of that case, my lord.
Therefore requires admission.
Very well. May I just pass on the
Earlier judgment, my lord.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಪೀಲ್ಗೆ ಹೋಗಿದೆಯಾ?
Appeal ಹೋಗಿದೆ.
ನೀವು ಅದರ ಅಪೀಲ್ ನಲ್ಲಿ ನೀವು ಸಕ್ಸೀಡ್ ಆದ್ರಿ ಅಂತಂದ್ರೆ ನೀವು ರಿವೈವ್ ಮಾಡಿಕೊಳ್ಳಿ. Why we should keep this in pendency? So otherwise it is covered by the judgment.
Your lordship,
We can't, otherwise why to keep them pending? Well, in other matters we have done that, na? Wherever, if you succeed, if this order is reversed by the apex court, this has gone against you.
Yes, my lord.
Therefore, tribunal has, whether there is any stay of this.
Notice has been issued.
ಮತ್ ನಾವೇ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ನಾವು ಮಾಡ್ಬೇಕು. You have seen that ಎಂತ ಅದು ಅಹಮದಾಬಾದ್ ಡೆವಲಪ್ಮೆಂಟ್ ಎಂತದು ಇಂದೋರ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ.
Yes, my lord.
ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್ ನೋ ಕೋರ್ಟ್ ಇನ್ ದ ಕಂಟ್ರಿ ಶಾಲ್ ಟಚ್ ದ ಪೇಪರ್ಸ್. ಅಲ್ಲಿ ನಾವು ಇಟ್ಕೊಂಡ್ ಕೊಡ್ತೀವಿ. ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಾಗ ಮುಗಿಯೋದು ಯಾವಾಗ? ನಾವು ಅಲ್ಲಿ ತನಕ ನಾವು ಇಟ್ಕೊಂಡ್ ಕೊಡ್ಲಿಕ್ಕಾಗಲ್ಲ. The matter is pending before the Supreme Court is no ground for admission of the appeal.
Your lordship, let it be adjourned for 2 weeks.
No, why? Barkali. The revenue is in appeal for laying a challenge to the ITAT order dated 30 January 2024, whereby it's a appeal in ITA number 994 of 2023, Bangalore 2023
Yes, my lord.
has been negative following a decision, a coordinate bench decision of this court in ITA number 346 of 2018 between Commissioner of Income Tax versus Messrs Canara Bank, disposed of on 10 February 2023. First, next paragraph. The revenue has raised the following substantial questions of law for consideration. First, learned counsel appearing for the SSC resist the appeal, contending that there is no error attributable to the order of the tribunal, since what it has done is the following. What it has done is that it has simply followed the law declared by the coordinate bench in Messrs. Canara Bank Supra. First up, we Supra. The contention of the panel counsel that this judgment is put in challenge before the apex court in SLP number or CA number.
ಡೈರಿ ನಂಬರ್ ಇದೆ ಅದಕ್ಕೆ.
ಇನ್ನು ಡೈರಿ ನಂಬರ್ in a dairy number so and so and so, and therefore the matter requires consideration at the hands of this court is difficult to countenance. First up, next paragraph. In the above circumstances, countenance, especially when there is no interim order, countenance, comma, especially there is no interim order, staying the
Your Lordship,
Canara
for
Bank
that one,
Supra.
my lord, I don't have any information about that one, my lord, but matter is pending. Only that much I can say.
Dairy ಇದ್ರೆ ಕೊಟ್ಟಿರಲ್ಲ ಅದಕ್ಕೆ. In the above circumstances, this appeal being devoid of merits is liable to be and accordingly rejected, reserving liberty to the revenue to seek revival depending upon the outcome of the challenge now pending before the apex court. First, in that connection, all contentions are kept. Cost made easy. Next.
May I please make one submission, my lord? I'm sorry.
Yeah,
In the previous matter, there is no need for interim order because it's a case of refund.
Refund hangagi entry matter ಬೇಕಿಲ್ಲ. Thank you. Yes.
Now application ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ. Thank you.
Great.
Yes. ಏನಮ್ಮ?
Yes, Your Lordship. The question of law is in page 17, Your Lordship. Question of law 1 to 5, Your Lordship, where the issue is while issuing the notice of 148 AD, Lordship, the notice has to be issued by the faceless authority, not by the jurisdictional AO.
ಏನಿದೆ ಲಾ ಅದ್ರ ಮೇಲೆ?
Lawದಲ್ಲಿ, my lord, there are contradicting judgments, but Delhi High Court has held in our favor. Let it be admitted. my lord.
Bombay High
Requires 1 and
Lordship,
3.
stay may be granted. On the last occasion, stay was granted, Your Lordship, but
Question number 1 and 3 would.
1 and 3. ನೋಡಮ್ಮ, appeal is admitted on the substantial questions of law 1 and 3. First up. ನೀವು ಈಗಾಗಲೇ ಅಪೀರ್ ಆಗಿರಾ ಏನಿಲ್ಲ?
yes.
Interim order
Interim order may be extended, Your Lordship.
continued. ಗಂಟೆ ಇಲ್ಲ. Interim order as prayed for. ಅದು
Match applies.
ಅದು ಕೆಳಗಡೆ we note that there is a conflicting there is
Lordship,
conflict of views
SLP number, Your Lordship, I'm
on the
providing.
questions raised in this in this appeal. Semicolon. Delhi High Court is said to have taken the view in favor of the revenue,
But whereas Bombay
whereas
High,
the Bombay High Court has taken the view.
not only Bombay
in
High
a
Court,
favor of-
Telangana High Court, Punjab and Haryana High Court, many of the high courts have taken in favor of the assessee.
Bombay High Court and other high courts
Yeah.
are said to have taken a contra view.
SLP.
This matter is pending.
But Delhi High Court has taken.
This matter is pending before the Supreme Court in SLP number.
That is Bombay High Court matter.
And that the matter, the question is at large on the floor of the apex court in SLP number. ಇಂಥದ್ದಿದ್ರೆ ನಾವು ಮಾಡ್ಬೋದು.
Yes.
ಒಂದ್ ಹಿಂಗ್ ಹೇಳೋದು, ಒಂದ್ ಹಂಗ್ ಹೇಳಿದಾಗ there is a substantial question of law.
Match applies, Your Lordship.
ಅಲ್ಲಿ ನೂಲ್ವಿ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇದಾರಲ್ಲ, ಅವ್ರೇನಾಗ್ಬೇಕು? ಓಕೆ, ಅವ್ರು ಬೇರೆ. Is a good advocate, senior advocate in Delhi. Yes. Sure. Writ appeal.
Short question of limitation, my lord. First appellate authority, tribunal, single judge, all take the same view.
that petitioner ought to, the appellant ought to have been vigilant about his rights.
Bandela. Call this matter in next week to enable counsel for the appellant to come and argue. Okay. Failing which appeal may be dismissed. First, registry to show shortly about it in the court list. Yes.
My lord, senior is on legs, my lord. Kindly pass or grant 2 weeks of time.
On feet ಅಂತ ಹೇಳ್ಬೇಕು. ನಾನು ಅದ್ ನೋಡಿದೆ, ಅದು ಆನ್ ಲೆಗ್ಸ್ ಅಂತ ಹೇಳ್ಬೇಕು, ಆನ್ ಫೀಟ್ ಅಂತ ಹೇಳ್ಬೇಕು ಅಂತ. ಸಾಮಾನ್ಯವಾಗಿ ಯೂಸೇಜ್ ಬೈ ಕೆವಿನ್ ನಾಯರ್, he says somebody is on feet ಅಂತ ಹೇಳ್ಬೇಕಂತ. ಇನ್ಮೇಲೆ ಹಂಗೆ ಹೇಳ್ಬೇಕು.
Yes.
All right.
My lord, I sincere apologize. I appear for serial number 20 petitioners.
20?
Please, my lord.
20, yes, argue.
My lord, senior is held up in another court. Kindly have it passed over to 2:30, my lord.
2:30, we don't sit not today. We have different combination.
Then I would request for a short accommodation, my lord, 2 weeks
That
of
may be
adjournment.
dismissed and further, but call after 2 weeks at the request of.
Grateful, your lordship.
Lord, kindly grant 2 weeks of.
On what ground?
My lord, senior is on legs.
Again on legs
Senior
only?
is on feet.
It's only on the ground that whether arrest can be made under 226 or not. They've challenged bail order granted in 226 on the ground that it cannot be made. Last occasion, your lordships had asked me a judgment to give on that regard whether under 226 it can be.
It appears you came running like P.T. Usha. Sit down and take rest.
Please note.
Your judgment.
Well, there are 2 judgments on this issue.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ. ಏನಂತ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಗ್ರಾಂಟ್ ಬೇಲ್ ಇನ್ 226 ಅಂತ. ನಮ್ದು ಹಿಂದೊಂದು ಯಾವುದೋ ಒಂದು ಓಲ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು, ವಿಚ್ A.K. Subbaiah had argued before this court.
Please.
2025.
This is the one regarding bail.
ಯಾವ paragraph, brother?
Well, it's in this case, kindly see para 21.
21. These are procedure to be followed while arresting.
Please. This judgment is regarding procedure to be followed, that grounds of arrest has to be issued.
Correct.
Without which they cannot be arrested. No grounds of arrest has been issued. The second judgment is regarding when bail can be granted.
By the High Court.
Please. Para 64 lays down the guidelines.
Aruna Goswami maternal.
Please. Guidelines at para 64 is provided, and what circumstances 226 can be exercised.
Para
64.
Come to 41.
Please.
Paragraph
4, my lords.
Sixty-six
64 lays down the guidelines, my lord.
guidelines. 66, read 66.
The principles are equally applicable to the exercise of jurisdiction under Article 226 of the Constitution when the court is called upon to secure the liberty of the accused. High Court must exercise its powers with caution and circumspection, cognizant of the fact that the jurisdiction is not a ready substitute.
Apologies. Very-
No problem. He said that.
Ready substitute for recourse to
Your
the
case is what? High Court cannot.
Illa, my case is, my lord, I humbly accept that. the writ-
Proposition is
pro-
true.
pro-
But
writ under-
invocation is not possible.
Only thing is that whether in the facts of this particular case, whether the invoking of extraordinary jurisdiction under 226 was justified or not. Because here, there was some imports where he has imported some articles which was in violation. We conducted an inquiry. We found that there is a more than 10 crore valuation that is, which has been evasion, tax evasion, my lord. And we issued an arrest memo, my lord. Now, the respondent appeared before the learned economic offence court and bail was rejected. Rather than going in statutory appeal, they have directly come to the High Court under 226, my lord. One, my condition is that they should have followed the procedure by going to the statutory appeal to the Sessions Court. Then here, they have directly challenged the procedure under section 69, whether the arrest or the arrest memo which was issued is proper or not. They have challenged it. In the interim, they filed a application for bail, and this and the learned single judge appreciated, taken in the application and considered and passed the order. Well, my humble submission is that I will not endeavor that yes, Article 26 it has got abundant power to entertain this thing, my lord.
Kodi. File kodi. Why you did not go under a regular process?
That is,
Yes, I had challenged the arrest itself in the writ petition, wherein bail was granted on 2 grounds, my lords. The entire allegation pertains to 2 companies to bring the total to 10 crores. Against my company, where I am the managing director, it is only 3 crores, which is a bailable offense. As far as the other company is concerned, I'm not even a director. I'm unconcerned with the other company. They merged the finances of 2 companies to increase it beyond 5 crores to arrest me, which is unjustified. On that ground, bail was granted because I'm not even a director in the second company.
Lord, it was on the statement given by the manager under whom the goods were seized, my lord. He had given.
Whether he is cooperating in the inquiry now.
Please, my lords, I am
Trial
abiding by all
ಆಗ್ತಾ ಇದೆನಾ ಈಗ?
conditions.
Andre trial ಆಗ್ತಾ ಅಂದ್ರೆ ಇನ್ನ it is not yet started. It's
The
going.
proceedings are stayed, my lords, by this honorable court.
All proceeding.
Yes,
Please, your lordships have granted the interim order of stay.
No, investigation ಆಗ್ಲಿ. ನಿಮ್ನ ಅರೆಸ್ಟ್ ಮಾಡೋದು ಬೇಡ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗೋದು ಬೇಡವಾ?
ಅಲ್ಲ, proceedings ಇನ್ನೊಂದು writ petition stay ಆಗಿದೆ. Both are clubbed together. Both the writ petitions.
Or WPs are clubbed together.
Both are clubbed together. One is this writ petition, my lords. The other one where proceedings were questioned in light of.
ಇಲ್ಲಿ ಯಾವ್ಯಾವ ಇದಾವ್ ನಮ್ಮ ಮುಂದೀಗ?
My lord, this is only the writ appeal questioning the bail order.
Questioning the bail order.
Bail order.
Please. The other 2 matters, my lords, would come before a single bench, my lords.
ಅದೆಲ್ಲ 3 ನಮ್ ಇಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ, ಅವಾಗ ಅಷ್ಟು ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
Please.
ಈಗ ನಾವು ಒಂದ್ ನಮ್ನಿ ಡಿಸೈಡ್ ಮಾಡೋದು, ಅವ್ರು ಇನ್ನೊಂದ್ ನಮ್ನಿ ಡಿಸೈಡ್ ಮಾಡೋದು ಬದಲಿ.
Both the writ petitions come before the same bench.
ಅಲ್ವಾ?
Please, this writ appeal, since it's questioning the bail order, it is come before a division bench.
ನೋಡ ಎಲ್ಲ ನೋಡ್ಕೊಂಡ ಆ ರೀತಿ ಸೆಕ್ಟೇರಿಯನ್ ಆಗಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಹೆಂಗೆ ಅಂತ both the sides submit that there are two more cases, namely WP numbers
1587 of 2023,
1587 of 2023 and so and so
19125 of 23.
19125 of 2023. Arising from similar fact matrix, same fact matrix, and therefore even those cases can be heard and decided along with this appeal, comma, by the same bench. First, registry to look into this. And seek appropriate direction at the hands of Honorable the Chief Justice in that regard. Okay. Call week after next.
I seek for a week's time, my lord. I need to prepare a compilation and I'll file the short synopsis also, my lord, for that.
Just
Land grabbing act, my lord. The act, it has no retrospective effect is my contention. my lord. The land grabbing act has no retrospective effect is my contention, my lord.
Retrospective alla.
That is in the case, the last time my lordship has passed an order to remit it back before the court.
Remand
But in
ಮಾಡಿದ್ರು.
this, they have assigned the proper reason, my lordship, while
Ah.
transferring to the.
Which date? Encroachment on which date? That will decide the division bench. ಯಾವ್ದದು ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಎಂತದ್ದು?
2021 Karnataka 385, my lord.
ಏನ್ ಹೆಸರದು?
Sunita versus state, my lord.
ಅಲ್ಲ ಅದಲ್ಲ.
That is.
ಇನ್ನೊಂದು ಮೊನ್ನೆ ಚಾಂದಿನಿ ಆರ್ಗ್ಯೂಡ್
This, my lordship. Arvind Kumar.
that is the judgment. ನಾ ಏನ್ ಹೆಸರದು?
ಅದೇ 47.
ರಾಜ್ ಅದೇ ತಾನೆ?
That is what the.
ಈ judgment. Shriram Properties. Date of encroachment ಏನಂತ
Yes, my lord. As per the on page number 73, my lord, of the petition compilation, the
3.
Yes, my lord. That is the notice issued to me on 22nd August 2013 by the government, my lord.
ನೋಟಿಸ್ ನಲ್ಲಿ ಯಾವತ್ತ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿರಿ ಅಂತ ಹೇಳಿ
They say that, my lord, I mean, I have committed the offense under section 192A of the Land Revenue Act, and I have the encroacher. That is the statement which has been made, my lord.
ಅಲ್ಲ what we want to know is
Yes, my lord.
whether offense is committed as on the date you encroach it or you refuse to vacate the encroachment.
My lord, I will put it like this, my lord. I lawfully I was put in possession by issuance of a grant order, my lord.
ಎಲ್ಲಿದೆ ಅದು?
Yes, my lord. That is by on 27/5/1964, my lord.
Order ಎಲ್ಲಿದೆ?
Order is not available with me, my lord. The order proceedings are mentioned in the revenue proceedings, my lord.
ಎಲ್ಲಿ?
Yes, my lord.
By virtue of grant order you are in.
Yes, my lord. Yes, my lord. If my entry is lawful, my lord, my contention is that I cannot be termed as an encroacher. That is my another submission, my lord.
ಅದೇ ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದಾರೆ ಇಲ್ಲಿ.
Yes.
ನೀವು ಅದನ್ನ ತೋರಿಸಿ ನೋಡೋಣ.
Yes, my lord.
ಸೂಟ್ ನಿಮ್ದೇ ಅನ್ನೋದು.
Yes, my lord. I have instituted a suit.
ಆ ಸೂಟ್ ನಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ?
Yes, my lord. At page number 79, my lord. The plaint starts at page number 76, my lord. At page number 79, para number 3, I have mentioned, my lord.
Grant order.
Yes, my lord. I have given the reference of the grant.
27/5/1964.
Yes, my lord.
This appears almost similar to that one.
Please,
Just
my-
look into.
My lordship, but in this annexure M, my lordship.
Annexure?
M, where civil court has passed in a detailed order by remitting back to the special court.
Ah.
Then petitioner had filed a writ petition before this honorable court. Writ petition came to be disposed of, directing the special court to consider accordance with law. Now the special court has taken consideration. Kindly see the writ petition which was filed by them, my lordship.
That's dismissed.
That was disposed of, directing to the special.
That the special court itself decided.
Please decide, I mean, accordance with law.
That itself is wrong because the jurisdictional court should decide on the hold ಮಾಡಿದ್ರು. Anyway, rightly or wrongly, there is an order.
But there was, there is an order in by annexure M by the civil court, my lordship. In that case, there was no such order. Only based on the notification, they have transferred this, but there is a detailed order in this, my lordship. Even special court has taken a detailed consideration regarding the trial court has blindly, they have
No,
not.
that's why I'm not on transfer. I am on the issue. When he is put in possession of the land by virtue of 1964
But that
grant
has-
order, how can you call
That
him
has
as
to be
a?
decided by the providing the documents before the special court again, my lordship. Because special court now restored the matter for the.
ಆ document ಎಲ್ಲಿದೆ?
My lord, we are not in possession of the document.
But ಅದ್ ಹೆಂಗೆ? On what basis you have ever?
On the basis, that is the proceedings, my lord. I was, on the basis of that, my name is entered in the revenue records also, my lord.
Suppose ಅದು falsely enter ಆಗಿದ್ರೆ?
My lord.
ನೀವು ಆ document produce ಮಾಡಿ, then we can grant some
They
relief. to you.
themselves has admitted for the 10 years they have been granted in the petition.
No, once it is granted for 10 years, he gains entry.
But they have not produced such a document.
ಅದನ್ನ ತೋರಿಸ್ಬೇಕು.
But my lord, the state is not disputing that particular grant, my lord. They admit that there is a grant
ಎಲ್ಲಿದೆ?
in their written statement, my lord.
Admit ಮಾಡ್ಯಾರ.
Sorry, my lord, I will.
So that 1.5 page written statement.
No, my lord, no. They have not admitted, my lord. Sorry.
Admitted.
No.
But at least ಆ document ನೀವು produce ಮಾಡಿದ್ರೆ,
Yes, my lord.
then we can grant relief. Otherwise how? ನೀವು ಒಂದು ಹೇಳ್ತೀರಿ, ಅವ್ರೊಂದು ಹೇಳ್ತಾರ, ಅದು ಟ್ರಯಲ್ ಅನ್ನೋದು ಅವ್ರು ಹೇಳೋದು.
My only endeavor is that, my lord, in the notice which they have issued, they have specifically mentioned that the encroachment is earlier to 2014. If the encroachment is earlier to 2014, my lord, then my lord, this particular act has no effect. It has.
2011 ಇದ್ರೆ?
Well, 2014 only, the act has
Act
come
came
into.
into force.
2011.
No.
Act.
It
Act
has-
is 2011.
But
It
amendment.
came into effect only in 2014.
October 2014, it has come into.
Correct.
effect. 24th October 2014, my lord.
ಎಲ್ಲ ನೋಟಿಸ್ನಾಗ ಎಲ್ಲಿದೆ?
Sorry, my lord.
ನೋಟಿಸ್ ನಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? And before 2014 ಅಂತ ಹೇಳಿ.
Yes, my lord. That is the statement, my lord. Page number 73, my lord, in the notice.
ಹಂಗೆ
they say-
ಹೇಳಿದಾರ?
Yes, my lord. That is dated 22nd August 2013, my lord. Earlier to that of the act coming into effect. 73, my lord. Page number 73.
22/8/2013. Yes, Sachandani, how are you going to maintain this? Covered by judgment, na? Act itself came in October 2014. But notice is this one. No, you can't maintain that. Just look into it, come back. You don't precipitate the matter in the court bill.
There is an interim order, my lord. My lord.
Entry order is
Yes,
there. Entry order to continue. You can't maintain it at all. Any act under Article 20, Clause 2, no ex post facto criminal law. Yaudadu? 22.
Yes.
No ex post facto criminal law.
Lordship,
ಹಾ,
small mention, my lordship.
ಹೇಳಮ್ಮ.
Serial number 17, 3 weeks ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿ, my lordship.
7
17.
17, Bardaitan.
After 3 weeks.
It's already written. Next time when it comes, you ask, we'll give time.
17. Nanto. Vision Sarla Swami or Atlanta? No, not Atlanta. I thought somebody was retiring in there. You are new counsel. No.
Hello, hello.
ಸರ್ ನಮಸ್ಕಾರ ಸರ್. ಇನ್ನ ಸಾಹೇಬರು ಬಂದಿಲ್ಲ.
ಸಾಹೇಬ್ರು ಬಂದಿಲ್ಲ?
ಇನ್ನ ಬಂದಿಲ್ಲ ಸರ್, ಬರ್ತಾ ಆನ್ ದ ವೇ ಸರ್.
ಓಕೆ ಓಕೆ, ಆಯ್ತಾಯ್ತು ಆಯ್ತು. ಅದೇ ದಿಸ್ ಮ್ಯಾಟರ್, ಅದು ಡಿಬಿ ಮ್ಯಾಟರ್ ಅಲ್ಲ? ಎಸ್ ಎಸ್. You engage a senior counsel in that matter. You engage senior counsel. Right. Last date of hearing, senior counsel Shankar appeared. So Nandakishore, this IAD have already disposed. Why this listed today? No. So once IAD disposed, then it's already disposed, alone. Once it disposed, it has to be listed before the regular roster. No, for serial number 1. So regular roster. Let us see. ಆನಂದ್ ರೆಡ್ಡಿ ಅವರು ಇದ್ರಲ್ಲಿ ಇದ್ದೀರಿ? ಫಸ್ಟ್ ಒನ್ ಡಿ.ಬಿ. ದಂಡಕೇಶ್.
ಗೊತ್ತಿಲ್ಲ ಯಾರು ಬರ್ತಾರೋ, ಇನ್ನ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ, ಇನ್ನ ಆಗಿಲ್ಲ. ಅದು ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ, ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಅವ್ರವ್ರ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಕೇಳ್ತಾರೆ, ಎಲ್ಲ ಚೇಂಬರ್ಸ್ ಹೋಗಿ ಯಾರು ವಿಲ್ಲಿಂಗ್ ಇರ್ತಾರೋ ಅವ್ರನ್ನ ಮಾಡಿ ಕೊಟ್ರೆ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಗೊತ್ತಿಲ್ಲ ಕೊಡಲ್ಲ. Matters pertaining to Kalburgi bench for order, scene number 1, Harshavardhan R. Mali Patil, Manvendra Reddy.
Yes. My senior had told me, never accept a review brief. You sink into your shoes, you will embrace the other side and perhaps earn the displeasure of the court. But I have the other illustration in life, namely 27 review petitions were argued by Mr. Parasaran, and he succeeded in all the 27. I am between these two situations.
You are another Parasaran of our High Court.
But the situation is this, Millard. We have two aspects are there. One is for acquisition in respect of laying railway lines. Throughout, starting from Privy Council, the courts have held. There's no question of development. Illi development expenses madidare. Adu because the advocate argued like that. 1. 2 is Karnataka High Court has division bench has given a ruling presided by Justice Narendra and Justice another honorable judge of this court. Following 2007 Supreme Court saying that in respect of acquisition of land for laying railway lines, no deduction is permissible. This is the two things apparently. Therefore, I mean, this should have been brought to your lordship's notice for 2 reasons. 1, my counterpart, he's Parasaran for me. Then, Millard, the other thing is Manavendra Reddy participated before Justice Narendra and Justice the companion judge, assisted the court by saying that this is the decision. It is not cited by us. He cites. And before your lordship, he cites something else. In a span of 23 days. The 1st September 2014, 1st September 2020, the other division bench has held. Under the same question proceedings, that deduction for railing line, there's no development involved, deduction is impermissible. Adan tamage heli Manavendra Reddy tam helbedve. So kindly, I'd only suggest these 2 ways of looking at it. Since the companion judge is far away, about 600 kilometers away from us. So is it better for us to argue when he assembles here?
When we sit
Yes, yes. The warmth of the learned judge will encompass us.
Mr. Manavendra Reddy is physically present here, sir.
Well, 2 things. Your lordship treat it as parted and post further hearing at the Markoli. So that I'm relieved. I'm relieved.
We'll sit together. We'll request
I request the honorable judge to countenance some patience till the honorable court comes here.
I will request honorable Chief Justice to bring our
Yes, I think
on Friday, so that together we can sit.
I think so. I think so, Millard. I think so.
Him there.
I appeared for.
On his behalf also, I'll be mentioning 2-3 words. If your lordship can dispose of that matter today itself, it's also like before. Second, Manavendra Reddy highlighted that one small aspect. Since my lord is a propounder of natural justice, he was not heard. The learned judge was not heard. He should have been. You have made a mistake and said, apologize for mugibodayitu. Adinda tavu adanna dayamadi explain madi. Dayamadi. This the only thing is a career of a judge is at stake. For the last 3 years, he has
There are 2 judges, 2 honorable judges who have passed the orders.
microphone.
There are 2 honorable presiding officers. Am I audible? There are 2 presiding officers who have passed the judgments in this matter on the same matter.
in a series of matters, they were all clubbed together and it came up before my lord. So against the remarks which have been made, they have been applicable to two of the judges who have sat during that period. So since this matter had been taken up to the Honorable Supreme Court and they had no other avenue, they had to file an application in the Supreme Court. The Supreme Court sent it back, the Honorable Supreme Court sent it back.
Maheshwari Sahib.
Please. No, my lord. That
Howದು?
is Justice.
ಹೌದು.
No. This is Justice Cowell, my lord. Not sure if you'll find it. Justice.
You are having so much of difficulty in
This call
three judges, Kanvalkar, Dinesh Maheshwari,
Ah.
and Navilkar.
and yes.
Honorable three judges they have taken pains to say that we don't express any opinion. There's nothing wrong with the
Not
order as it stands,
expressing.
but you are at liberty to urge all these contentions. And I have added one more thing. If you lose review, come here. Don't worry. So therefore,
Since the main review itself was being sent back, the liberty was given. We were told to file this application before my lord.
This is for expansion of the
Expunction of the remarks made.
only that much.
Only that much. We cannot argue by whatever the merits or demerits we have.
Because it has attained finality.
Please, my lords.
On merits, it has attained finality.
My lords, on merits, the attempt is now being made for review of this. I have no opinion on that.
I think my lord's question is loaded. My lord may not have understood the implications. If your lordship's order has become final, if there's a merger,
Then where is the question?
where is the jurisdiction is not
But
here. Therefore,
for expansion, since they themselves said, you approach the
will
court.
not disturb the order ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ
That's
ಸ್ವಲ್ಪ
why.
ಕಷ್ಟ ಆಗುತ್ತೆ.
Correct.
ಕಷ್ಟ ಆಗುತ್ತೆ. ಅದನ್ನ ಈಗ ನಾವು ಮತ್ತೆ ತ್ರಿಶಂಕು ಅವ್ರಿಗೆ ಇಲ್ಲಿ ತಾವು ನನಗೆ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ ಬಿಕಾಸ್ ಮೈ ಆರ್ಡರ್ ಇಸ್ ಅಫರ್ಮ್ಡ್ ಅಂತ ತಾವು ಹೇಳ್ಬೇಕು ಫ್ಯಾಕ್ಚುಲಿ. ಹಿ ಸೇಸ್ ದಟ್ ಅಲ್ಲಿ ಹೋದೆ ಇಲ್ಲಿ ಹೋಗು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ. ಸೊ ಈಗ ಹೀಸ್ ಫುಟ್ಬಾಲ್ ಏನೋ ಅಟ್ ಅವರ್ ಫೀಟ್. ಹಾಗೆ ಆಗಬಾರ್ದು.
ಈಗ ನೀವು ಅಪಿಯರ್ ಆಗೋದು ಆ ಜಡ್ಜ್ಗಳಿಗೆ.
ಇಲ್ಲ ನಾನು ಅಪಿಯರ್ ಆಗೋದು ಪಾರ್ಟಿಗಳಿಗೆ. ಬಟ್ ಕಂಪೇರ್ ಟು ಮೀ ಹೀಸ್ ಎನ್ ಯಂಗ್ಸ್ಟರ್. ಐ ಥಾಟ್ ಐ ಶುಡ್ ಅಸಿಸ್ಟ್ ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್ ಇನ್ ಲಿಮಿಟೆಡ್ ಮ್ಯಾನರ್. ಅದು ಒಂದೇನ ಹಿ ಹಸ್ ನಾಟ್ ಬೀನ್ ಹರ್ಡ್ ಬಿಫೋರ್ ಪಾಸಿಂಗ್. ಅದನ್ನ ಅಲ್ಲಿ ತಮಗೆ ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್ ಬಗ್ಗೆ ನಾನು ನಿಮ್ಮ ಬಗ್ಗೆ ಹೇಳಿದ ಐ ಆಮ್ ಟೂ ಸ್ಮಾಲ್.
ಅವ್ರು ಬರ್ಲಿ.
ಆಯ್ತು ಅಷ್ಟೇ.
ಬರ್ಕೊಂಡ್ಮೇಲೆ
I join him by saying that please explain those remarks.
Heard learned senior advocate Mr. S.P. Shankar appearing for the review petitioner in RP number 20014 of 2022 na 21 ಇದೇನಿದೆ.
ಹೌದು.
22 ಅಲ್ವಾ? What of sir?
22 minutes.
22. And learned counsel Sri Nitin Ramesh.
Your presence.
Appearing for
Applicants in IA number 1 and 2.
applicants in IA number
1 and 2
application in IA numbers 1 and 2
of
of
2024.
2024 filed in the said review petition.
Please.
My lord, the presence of Mr. Manavendra Reddy and Harshavardhana Patil may be noted. Their presence.
We are yet to hear learned counsel, learned senior panel counsel, Mr. Manavendra Reddy and Harshavardhana Patil.
Yes,
Patil for the appearing parties, and they are present before the court. First up. Post this matter. Week after next ಹಾಕೋಣ. My brother comes here, it becomes easy. So that we'll request our Honorable Chief Justice, so that some Friday you can be here.
That place the matter for ಅಥವಾ ತಾವು ಬಾಯಿನಲ್ಲಿ ಹೇಳಿದಾಗ
Post this matter.
ಡೇಟ್ ಕೊಡ್ಬೋದು ತಾವು ಅವಾಗ. Date
could fix the date only so far as administrative convenience of his lordship, because the the Honorable Chief Justice need not fix another date for the bench, because his bench is already constituted. Only for the limited purpose of convenience, if you like.
ಅವರಿದ್ರೆ ಸ್ವಲ್ಪ ಅವ್ರು ಇಟ್ಕೊಂಡು ಮಾಡುವಂತ ಕೆಲಸ ಇದೆ.
Very well, I get that. Not anything else, just the date factor, if it can be a short.
When this bench assembles in person,
Please,
in person.
Please. Great.
all those matters, sir.
All those.
Please.
Yes.
Great. ಅದೆಲ್ಲ connected matters, sir. ಇದಿಗೋಡು.
Yes. Yes.
Yes.
ಆಯ್ತು.
How are you?
ಅಯ್ಯೋ 124 ಇನ್ನೊಂದು ಹೊಸದು ಹಾಕಿದಾರ ರಮೇಶ್ ಹೋದ್ರಾ ರಮೇಶ್ ಅವ್ರು ಹೋದ್ರಾ ಕರಿಬೇಕಾಯ್ತು
ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ವಲ್ಲ ಪುಟಪ್ಪ ಮಾಡಿಲ್ಲ 102/2024.
ಅದೊಂದು ಹೇಳ್ಬಿಡ್ತಾ ಯಾವ ಅಪ್ಲಿಕೇಶನ್ ಅಂದಿದ್ ಮೇಡಮ್
1/2/2024
ಇದೆ ಬಟ್ ಅದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಳೇದು ಅದೆಲ್ಲ ಆಗಿದೆ ನಮ್ಮ IA1 ಅದು ಹಳೇದು 22 ಸ್ಪಂಜಿಗೆ ಸರ್ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಟೋಟಲ್ ಡಿಸ್ಪೋಸಲ್ ಎರಡು ಏನಕ್ಕೆ A1 ಏನಂತೆ IA1 ಏನಕ್ಕೆ ಸ್ಪಂಜಿಂಗ್ ರಿಮಾರ್ಕ್ಸ್ ಇವರು ಅದನ್ನೇ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ ಅಕಾರ್ಡಿಂಗ್ IA1 ಟು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಈ ಅರ್ಜೆಂಟ್ ಬರುತ್ತೆ
ಎಕ್ಸ್ಪಂಜಿ ಆಗಲಿಲ್ಲ ಡೈರೆಕ್ಟ್ ಅಲ್ಲೇ ಡಿಸ್ಪೋಸ್
ಮಾಡದ್ರಲ್ಲ ಬಿಡ್ರಿ ಹಂಗ್ ಮಾಡಿದ್ರೆ RP ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ
ಮೇನ್ ಇಶ್ಯೂನೇ ಎಕ್ಸ್ಪಂಜಿ
RPನೇ ಹೊರಟೋಗ್ಬಿಡೋದು ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಮಾಡೋದು ಮಾಡಿ IA1/23 ಇದು ಬೇರೆ ಇದು ಕರೆಕ್ಟ್ ಇದೆ ಇದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೇಳಿದ್ರು ಮಾಡ್ಬೇಕು IA1/23 ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಇಸ್ ಡಿಸ್ಪೋಸ್ ಅಂತ ಹಾಕ್ಬೇಕು
ಇವಾಗ ಏನಿದ್ ನೋಡ್ಸೋದ ಆರ್ಡ್ರು
ಅದನ್ನ ಹೇಳ ಅನ್ಕೊಂಡೆ ಇವ್ರದ್ದು ಯಾವ್ದು IA ಬಂದ್ಬಿಟ್ರು ಅದನ್ನೇ ನಾನು ಯೋಚನೆ ಮಾಡ್ಕೊಂಡು ನಿಂತಿದ್ವಿ ಯಾವಾಗ ಎಲ್ಲಿ ಅಂತ ಅಯ್ಯಪ್ಪ ನಾವು
ಫೋನ್ ಮಾಡಿ ನಿತಿನ್ ರಮೇಶ್ ಇವಾಗ ನಾನೇನು 1/2/2024
ಅದೇನ್ ಹೇಳೇ ಇಲ್ಲ ಅವರು
ಮತ್ತೆ ಇವಾಗ ಅದಾದ್ರೂ ಕೇಳ್ಬೇಕು ನಾನು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು
ನೋಡಿ ಇವರು ಅಸೆಟ್ ಮಾಡಲ್ಲ ಸರಿ